On the constitutional floor that you were just exploring, I want to ask the questions to you that I was exploring with Alabama's counsel. If the median is above 70, I understood them to say that the defendant cannot make out a successful Eighth Amendment claim, even if they might have something under state law. Do you agree with that?
I don't think that the Eighth Amendment necessarily speaks to that one way or another. I mean, again,
so you don't agree with that then?
Well, I think that the standard for what the Eighth Amendment is, at least under Atkins, is going to only the Eighth Amendment strictures are only going to reach as far as a nationwide consensus mandates. So when it comes to those specific issues, to the extent there's no nationwide consensus on the question, no, I don't think you run afoul.
So what happens when the median is above 70? Or when I assume you're going to have the same answer on the overlap as well. So the overlap approach, let's say as here, 73 to 77, they're saying when that's the case, you cannot make out a successful Eighth Amendment claim, period.
I think that.
Do you agree with them on that?
So I agree that it's practically dispositive under law.
You said that. I wrote that down. Practically dispositive. What does practically, as opposed to legally dispositive, mean?
Because I think that it's not to say that that there's some per se legal error to moving on to other evidence in light of
the other evidence. Then, when you move on, if you're saying they can move on, or over the state's objection, you're saying the other evidence, in some circumstances, could outweigh the scores even when the median's above 70. Let me finish. Or when the range is something like 73 to 77. In those circumstances, unlike the state, you're saying the other evidence could outweigh in some cases.
I'm not saying it could outweigh. I think there's a difference between a constitutional rule as to whether or not you need to consider it. But I think in a circumstance where you have consistent scores that are in the high 70s, this is what I mean by practical.
Well, if you're saying that you could consider it, but it's not dispositive, like the state says, then I'm trying, is this just for going through the motions, or what? But
I think this is a product of, again, this is going to be a product of state experimentation. If you have a totality of the circumstances inquiry in some measure, it doesn't mean all the evidence is equally important. So even if you decide to look at other evidence for one reason or another, the IQ scores might be so strong that there's no realistic possibility that other evidence is going to drag the IQ scores down.
I'll ask it again. If the median's above 70, the state says end there. You're saying no. You can go on to consider the other evidence. The defendant can have you go on to consider the other evidence. In some cases, can the other evidence outweigh the scores even when the median is above 70?
So yeah, I can imagine a circumstance hypothetically where, so suppose you have—
that's a yes, that's okay, that's different from the state.
Again, I think that, so imagine a circumstance where you have two scores of 71. And then you come in and essentially you have an expert say, well, the content of those IQ exams tested A, B, and C aspects of intellectual functioning. I have all of these neuropsychological batteries that test other aspects of intellectual functioning, and they're really, really low. I could imagine that being, in a state that has decided to adopt the totality of the circumstances inquiry. That would be a kind of circumstance where, yes, the other evidence could pull you below the line.
So I think it would be constitutional error then for a court to say the median is above is 73. That's the end of it. You can't prevail on an Eighth Amendment claim. That would be constitutional error?
I would be so I think that I would be reluctant to phrase this in terms of median, composite, whatever it might be. And this is what I was trying to get at a little bit with Justice Kagan, is that there is some point, and Hall, I think, blesses this practice. There's some point where the possibility of your scores dipping to 70 or below, is remote enough that you can rely on IQ exclusively. I don't think this court's precedence paints with a bright line. It certainly doesn't mandate at this point a specific median number, but I think that's the nature of the inquiry.
That's where you differ from the state. The state really was pretty definitive on that, and you're not, which is fine. I'm just trying to explore, because we're going to have to dig through a lot in this case to explore kind of the difference.
But again, this is, returning to the part of, is it a real world matter? I don't think it's going to make any difference here with the idea of—
Here meaning in this case?
Correct.
Okay, that's all I need. Thank you.